Let's get this started. Well, welcome everybody. My name is Gary Kreissman. I am an advisory board member for Royal, and today we're going to be talking about who owns you. This is the third, I believe, in a series of seminars about who owns you, and the specific topic today has to do with AI, identity, and the future of creator endorsements. So just a little background before we get started. For over 20 years, creators have monetized attention more than assets. The attention has been about downloads, about views, followers, sponsorships, but in today's era, there's a fundamental change, and the monetization of identity itself has changed. So as a creator, your voice, your archive, your experience, your face are now assets that can be licensed and distributed at sale. And a lot of that has led to conversations about protection. And most of that's been led by fear, scraping, deep fakes, copyright issues. But the session we're going to have today is a bit different. We're going to be talking about protection, but beyond that, we're going to be asking, how do creators leverage their identity on their own terms? How do they provide consent? How do they get compensated? I think that's important to everybody. And how can you control these assets that are increasing in value? So the title of our session isn't rhetorical. The idea of who owns you. Many creators who are here may have already signed away rights that they don't know they've given up. Those can be buried in terms of service, and many are looking at assets like an archive or a distinctive voice or a look or a trusted persona that are worth more than they realize. So the core questions changed a bit. It started with, can AI replicate a creator? Well, now obviously that's the case. Today it's who authorized the use, under what terms, and how is that consent given? And how does an audience know when they hear an endorsement? How do they know it's real? So by the end of this session, we want you to leave with a much clearer picture of what you actually own. The questions that you want to ask in addition to that, and a better understanding of how brands and AI companies think about deals and the kind of steps that you individually as a creator can take to monetize and to protect the work that you do. So let me introduce the panelists who are with us, and then we'll get into a series of questions. I'll encourage everyone in the audience to send questions to us via the chat. Don't worry about interrupting the flow. It's up to me to kind of integrate the questions as we go. But I think we'll have an interesting hour, and I'll begin by introducing Rob Greenlee, who has the perspective of being a podcast industry veteran and really is a pioneer. He put his talk show online back before podcast was even a word. And now he's in the Podcast Hall of Fame and chair of that august organization. Rob has helped shape the medium from inside the industry's biggest platforms, leadership roles at Microsoft, Podcast One, Spreaker, Libsyn, and he was VP of Content and Partnerships there. He's also the longtime host of the new media show, podcasthall.com. And he's an advisor to creators, networks, tech companies on where digital media is heading. So Rob will bring you firsthand experience on the very thing that we're discussing, because he's gone through the process of verifying and licensing his own identity for AI use. So he'll be able to speak to what this feels like as a creator, not just the concept, not just the theory. Matt Savare has the legal framework here. Matt is a partner at Lowenstein Sandler, and he advises media, technology, entertainment, and advertising companies on intellectual property, licensing, AI, emerging technology solutions. He's also the co-author with the IAB of the AI Intellectual Property and Transaction Playbook. And that is a seminal document for digital advertising, literally helping write a lot of the industry's rules for how AI and IP interact. Matt writes and he speaks frequently on digital rights, right of publicity, AI regulation, including new disclosure laws governing AI generated likenesses. And he's here to probably, or at least we hope, take some of the mystery out of the legal side and clarify what you own, what you're giving away, whether you know it or not, and what a good licensing deal actually looks like. So with that, we have a great panel here. I want to start with a few questions, and again, I'll encourage you all to add others as we go. So, Rob, let's start with you. You've made the case. Sorry, do we have a comment there? Okay, sorry.
I think so.
Rob, you made the case that AI has moved creator identity, and this is quoting you, from something we express into something others can reproduce at scale. For a podcaster or a YouTuber who thinks, hey, I'm not famous enough for anybody to clone me, why is this relevant to them now, not 5 years from now? And how can creators kind of grab that power back?
Yeah, I think it's a multi-pronged question that has kind of a complex answer, but creators today have really the exclusive thing that they have is their likeness and their voice, their mannerisms, their real, that's the real core of what they bring to the market with their content. So if you're a content creator, those are your core elements that you have to offer to the market. So as we move into this new era of AI generated content, it basically, you have to start thinking about the options that exist are increasingly coming into play with content creators now. Is that there's likeness licensing, which is reproductions of you that are reproduced by AI, but then there's also licensing of you into platforms that that you want to get monetization and distribution inside of. So, I think as you look to the future, it's not so much 100% about likeness or reproduction, but it's also about taking your voice and your kind of image, your way of being, and replicating it into derivative content too. So just to give an example, a person that's creating content online could be converted into an animated character, right? Or could be made into, an exact replica that's generated by AI. And so you as a creator need to be in control of your likeness and your personal brand. And that's what really pulled me to the Royall.ai platform, was this ability to create a vault that basically stores my full life, voice, likeness, everything into a vault that then can potentially be used in licensing opportunities, content creator opportunities, as well as just being able to hold on to your identity. Because you look to the future, it's going to be very easy for people to replicate you, especially as you become more popular out there. And that, I think we're already seeing it with some big creators like Joe Rogan or Tucker Carlson or whatever, where people are capturing likeness and making ads, right? Or they're making other types of content with that likeness. And these AI platforms are doing it as well. So, how do we keep control of this is the key issue. And there's income opportunities here, but there's also just control of your ability to control how your voice and your likeness gets presented in the world.
Makes
Can I
sense.
put a little legal wrapper around that, Gary?
Please do.
Yes,
Because
please.
I'm not a lawyer.
No, but I mean, I think you framed 1/3 of the stool really well. I think there's really 3 buckets of intellectual property that we should talk about.
Sure.
One that Rob just talked about is right of publicity, persona, image rights. That's the ability of individuals, whether you're a celebrity or not, to protect any indicia of your persona. So that could be your name, your image, your likeness, your signature, mannerisms, all of the things that Rob discussed. Then another bucket are copyrights, right? So if you have original works of authorship, like a podcast or a book or a magazine or a YouTube video, those are all subject to copyrights.
Right.
And then you have a third bucket, and we're seeing a lot of celebrities do this now where they're actually trademarking their personas.
Yeah.
So you're seeing Taylor Swift and Matthew McConaughey are trademarking their name, their catchphrases, certain slogans they may have. So those are the real IP buckets that I would emphasize that creators have. So not only name, image, and likeness, and I know we're going to talk mostly about identity, but those are really the 3 buckets. And then one last thing that I wanted to mention, because Rob talked about having, being able to utilize your persona and integrate it into a game or something. I was actually, right before this webinar, I was on a phone with one of my clients called Bounce Kids. They're a early stage startup. And what they're doing is they're a gaming platform for kids. And one of their games allows you to, it's an exercise app. And what Bounce Kids is now doing is they're going out to content creators, celebrities, athletes, celebrity trainers, and they're saying, okay, license us your name, image, likeness, mannerisms. We'll do some motion capture. We'll get your persona down, and then we'll be able to integrate you into a variety of different games. So if you want to do, I don't know, body weight exercises, we could have Arnold Schwarzenegger, for example, doing push-ups or doing, deadlifts or chin-ups or whatever. And Arnold is not the one that's actually doing it. It's AI generated using his voice and his image. So the sort of the opportunities of exploiting, and I mean that in a good way, not exploiting, in a bad way, although that's an element I'm sure we're going to talk about, but taking advantage of and commercializing your persona, there are so many various ways to do it, and AI is just going to accelerate and exacerbate that. So I think it just opens up a world of different opportunities, and that's just one that I dealt with about an hour ago.
Yeah, can I add one more twist on that too, as we look to the future? Because I come out of the podcast industry, spent a lot of years in that area, and one of the frictions that have been around podcasting for many years is the creator having power over bigger platforms, and being able to counterbalance the massive power, let's say, that a YouTube has or a Spotify has in the market, right? To have that content creator feel like they have their own terms of service of sorts that gets applied to your content being used in those big platforms, because those big platforms have these massive terms of service agreements that you have to opt into. Well, why can't the content creator create terms of service that the platform that you're making your content available in has to adhere to create more of a balanced relationship? Because it's really out of balance right now, and it's been that way for a long time. And that was one vision that I thought for this at some point, is that there are typically larger content creators that will get into these licensing deals with these big platforms because they have market power, right? And the big platforms want that access to that audience. Well, smaller creators don't have that same lever of power because there's no consolidation of influence that exists around smaller creators coming together and saying, well, Spotify, these are our terms of service. And this is backed up by, tens of thousands of content creators that are doing the same thing. And so that kind of puts those big platforms in a position where they need to, offer a better deal or offer better opportunities to content creators, and not be at the whim of their value equation is exposure is the only thing that they can bring to the opportunity of a content creator putting their content into their platform.
I think, Rob, you make a good point in talking about balance, because the power is shifting and it's constantly changing. And I think a lot of it has to do, and this is something Matt can probably weigh in on, it has to do with the extent to which all sides in this equation are aware of what they actually control and what they've already given away.
Yeah.
And Matt, I'm curious if you could give some examples of situations where a creator, large or small, has discovered, hey, I thought I retained the rights to this, but apparently through terms of service with this player or that, I no longer have it.
I think probably over my 23-year legal career, the most egregious land grab that I've ever seen was on Shark Tank. I know that's a little bit different than what we're talking about, but participants on Shark Tank years ago just signed away literally everything, even if they weren't even on the show and it didn't air. I mean, it was egregious. And over the years, it has gotten more favorable for the participants. And I think the same trend is true for creators. I've drafted all of those lengthy terms of service and privacy policies that no one reads until there's a problem. And I've drafted, so I represent content creators, but I also represent platforms and agencies and ad networks. I'm sort of agnostic. I'm across the whole ecosystem. So I see it from every conceivable angle. And I think the trend, although I agree there's still an imbalance, when I first drafted terms of service, a lot of times for user-generated content, the trend was, okay, anything that you upload to the platform owns, and the platform can do whatever it is they want with it. You, creator who uploaded it, have no economic right. You've conveyed all intellectual property rights to the platform. We can do whatever we want with it, including using your name, image, and likeness to advertise and market the platform without compensation or attribution. It was egregious. And I think the trend has
derivative content too. Derivative content.
Yeah.
Right?
I mean, it was great. It was literally crazy. And things have gotten progressively better. And I think part of it is there's more competition. So, and there's a groundswell. Okay, geez, I just uploaded a really interesting video that got 1 million views. You're telling me I don't own it? And you're telling me that you can commercialize it directly, create a derivative work, as Rob said, right? I created a video, and now all of a sudden it appears in a commercial, and you're using my name, image, and likeness. So the things that are buried in those early terms of service were clearing the rights for name, image, and likeness rights, and being able to utilize the person's persona without compensation. So the trend has gotten better. We still need more protection for creators. And I love the idea of having sort of collective action, kind of like what we have with like ASCAP, BMI, and CSAC for music composers. So there are problems that are still buried in there. So the minefields when I'm advising talent, whether it's a celebrity or whether it's just someone that is an influencer or a content creator, not necessarily a celebrity, is before you post anything on a third-party platform, you should really understand. We don't expect you to be attorneys, but this day and age, copy and paste the terms of service into a chat GPT or something and ask, what exactly am I giving away, or what am I licensing? And in turn, what am I getting in exchange for that? And oftentimes you will see it's no longer the platform owns the content, but the platform will often have a perpetual non-exclusive license, meaning they could use that content forever, meaning they could use it usually as you've presented it on the platform, the things you want to avoid, as Rob already alluded to. Okay, I post a 5-minute video onto YouTube. I don't mind YouTube playing it on YouTube, but can they cut that down to a 30-second spot and put it somewhere else? Can they utilize what are called derivative works, something that is derived from my original submission? Can they use my name, image, and likeness to advertise YouTube? Maybe that's good, maybe that's bad, but can they use it and use the likeness to advertise one of their sponsors, right? Completely out of context. Maybe that's a little bit more problematic. You want control over your content. You want approval rights over usage of your name, image, and likeness. So a lot of things could be buried in those terms. So I would always encourage people, before you post, at least have a general understanding of what the terms are. And then we're probably going to get into, actual negotiated agreements, not click-through terms of service when you sign up for YouTube or TikTok or Instagram, but
Right.
someone approaches you to use your content or to license your persona, and they hand you, a 25-page PDF or Word document. Geez, what do I do with this? Those are, more negotiable than the terms of service, which you can't really negotiate with YouTube. But there are certain things that you can do in these agreements that you're going to get, whether you're agented, if you have an agent or not. And there are things that we can discuss during this webinar, some things to look out for when you're actually able to negotiate terms. But I think those are the things that I would look for in those terms of service, some of those minefields that are buried.
So, Matt, let me follow up with you on that one, because the idea of taking the long terms of service, throwing them in a chatbot, letting it kind of digest and telling you where your vulnerability is, that sounds good. But then if you're an independent creator, right, and you don't have the deep pockets to hire representation, what can you do about it? I mean, how can they push back to a corporate situation where there are rules of the game and they're saying, well, I don't agree with that?
Right. So some of the best deals that my clients have made are the deals that they didn't do. For
Right.
example, we've had a number of people, and I don't mean to pick on Shark Tank. I'm sure they're all wonderful people who do the production, but and the contract admittedly has gotten better. But I have advised a number of clients earlier, 5-10 years ago, not to go on the show, because if you go on the show, it's going to potentially preclude you from getting venture capitalists to invest in you, because the terms that you're signing up to are so egregious. So a lot of the platforms now, there's sort of everyone is sort of gravitating towards very similar terms. It's perpetual grant, it's non-exclusive. The creator can do whatever it is they want with it. There's usually not we can use your name, image, and likeness for anything you want. But if you run it through a chatbot, or you have a friend who's an attorney, or you have an agent that could look for it, or you just read it. A lot of the language, if you see the words exclusive, right, that should trigger something. If you see perpetual, that should trigger something. For any and all means or media, those are, whenever you see all, any, exclusive, forever, perpetual, your antenna should go up. If you don't have the means, and most people don't, even mid-tier talent aren't going to really be able to negotiate with a YouTube. So if you don't have the ability to negotiate, either because the platform is too large, or you don't have the wherewithal or the means to do it, don't post on that platform if the terms are not advantageous to you. Do your own distribution, or go to a platform that might be better suited for what you're doing. There's so many different platforms right now. Some give you a broader distribution, but the terms are not as good. Some are a little bit more niche, and they're more creator and artist friendly. So that would be my best advice, would be, if it doesn't fit, right? I don't want to sound like Johnny Cochran, but if it doesn't fit, you must don't use the platform if it's not the right fit for you, because you're not going to be able to negotiate with YouTube unless you're, A-list talent.
Yeah.
That's great.
Yeah, and I do think that we're moving in that direction. I think the larger platforms have been playing a little unfair for quite a while now with content creators. And I think that there is a movement towards more direct creator to viewer and listener relationship models out there. And I think we are pushing in that direction increasingly, because of the onerous relationship that has existed between smaller creators and the large platforms. They feel, smaller creators feel like they're kind of getting taken advantage of. And oftentimes that's the environment that these big platforms create, is that,
Robin,
like you just said, they only want to do favorable deals to the A-list content.
Rob, in your mind, what are the key questions, let's say 3 or 4 key questions that a creator needs to ask themselves before they sign a deal to license any of their image, name, whatever?
Well, I think it's difficult because, most creators are just looking for economic opportunities here, and they're willing to give up a certain amount of rights to accomplish that. And so, I do think that we're heading into an era, especially with this likeness platform, where it's going to be easier to be a little bit more diligent on that. And as we see a collective movement towards individual creators taking more of a step here that would put them in a better position to not necessarily negotiate, but to just enforce their principles that would be out there. And I think if you think back to the earlier era of the internet around copyright, with the Creative Commons type of models that were out there, creators were able to take a little bit more control and put that out there and say that these are the rules that I'm playing by, and I want you to play by if you want to use my content. And I think to some degree that's maybe what we're starting to create, just at a deeper level now because of AI.
Thank you.
Can I expand on that just a little, Gary?
Yeah, please.
Of course.
Yeah. So what I would say, again, we're not talking click-through terms of service. We're talking about an actual negotiated agreement. The things as an attorney that I would look for, or the agents, or if the creators are negotiating it on your own, the terms that I would look for in those types of deals would be the term. How long do they have the rights to use my name, image, and likeness? What's the scope of that right? Right? Can they use it only in one narrow usage? Can they use it for a bunch of different things? Can they distribute it? Can they make derivative works? Again, that's a work that's derived. So if I write a screenplay, if I write a book, right, the book is the work, and a derivative work would be a screenplay based on the book, or I have a podcast and you're making a documentary that's derived from the podcast. Do they have the rights to make those derivative works? Rob already alluded to it. What's the compensation? As a content creator or an artist, am I getting a guaranteed minimum, right? So I'm licensing this for 5 years, for example. Do I know that each year I'm going to make at least $5,000, $10,000, $50,000, or is it just a pure rev share? What's the rev share based on? Is it on gross? Is it on net? That's something that's important. And then probably one of the most important things is whether or not it's exclusive or not. Yeah. Right. So if you're granting them exclusive rights, and I'm not just talking about name, image and likeness. I'm also talking about you may have trademarks, you may have copyrights in your work, and a lot of times it won't just be a name, image, likeness license. You'll also see professional services associated with it, and maybe licensing of copyrighted content. So if you do an exclusive deal with someone, that means you can only do the deal with them. They're the only ones who can use it, distribute it, whatever the scope of rights is, even as it relates to you. So you may have to stop doing certain distributions. So it's really important to understand whether it's exclusive or non-exclusive. And then there's a whole bunch of other things that probably, too much time to get into now, but territorial, right? If you have content that is
U.S. versus other, for example.
U.S. versus global versus, I'm only letting you distribute this in Japan on a Tuesday, right? You can slice and dice it however narrowly you can negotiate, but it doesn't have to be. And a lot of creators, think that, oh wow, I got a deal, this is great. All right, it's global, it's perpetual, it's exclusive. These are fine if you're being compensated for it, but it may not be fine, right? So you really have to understand your worth and understand that you can slice and dice it however makes the most sense for both sides. But I think that's, from my perspective, the biggest takeaway when you're negotiating the agreement is Don't jump at the first offer. Don't feel that's the only offer. Know your worth and make sure you really understand the terms of the deal. And it doesn't have to be global, perpetual, no holds barred. It could be really narrow and
Right.
circumscribed. Yeah.
Matt, since you've given a number of good points here, and I know that you literally wrote the book about these issues, where would you advise somebody who's listening to find a checklist to make sure that they're going into a negotiation with their eyes open?
So if you have an agent, the first stop is usually the agent, because the agent is the person who's going to be negotiating the deal memo, bringing it to you and saying, okay, here are the terms that I've negotiated for you, the high level terms that I just went over. So if you have an agent, that's always your first stop. If you have an attorney or a person like Gary, as an advisor that could walk you through it, or someone, who has been through it like Rob, you have a friend like Rob, and hey, how have you structured it in the past? There's no shortage of information out there. And as much as attorneys want to deny it and say it's not as good, or like, really the chatbots are absolutely astonishing how much information you can get. So I say utilize them. Understand that they're not providing legal advice. Understand that, yeah, they hallucinate. Maybe it's not 100% accurate. But as between, no advice and having a chatbot, I'd rather chatbot advice. And you can say, what's market? Here's my website. Take a look at the website. Look at who I am, how many followers I have. Here are all my metrics. What's a reasonable deal based on past precedent? What are terms that I should be negotiating? Give me, sort of a no way, Jose, and yeah, that's a decent deal, to, yeah, I'm, on cloud 9 here. It could really differentiate for you. So I would say use your network, utilize technology that's out there. And if you're a creator, and for a number of years, I did a lot of pro bono, that's no charge, for VLAs, volunteer lawyer for the arts. So many years ago, I won the New Jersey Volunteer Lawyer for the Arts, because our firm is very supportive of the arts. And for, I don't know exactly what it is, whatever state you're in, every state has a VLA, and it's usually, I don't know, if you make less than $50,000, there's a financial component to it, but if you qualify for your state's VLA, you can get very good pro bono service at no charge to you. So I would encourage people in the audience, if you are limited means and you're looking for pro bono service, there are avenues for you to get top level legal advice without having to pay for it.
Great to know. I've got a few questions from the audience. Let me paraphrase one, and it has to do with recourse. What recourse would a small creator have if their content has been used against their terms and conditions? Does that necessarily require hiring representation? Are there other actions they can take? Are there enough standards where a creator might be able to say, hey, you guys are in violation?
I'm happy to take that, Rob, if you want to.
Yeah, I'll just make a comment on that, and then I'll hand it off to Matt to have a legal perspective on it. But
thank you.
I would say more than likely, most of the big platforms have terms of service that are so open to doing pretty much anything they want to do, is that you probably don't have a lot of legal recourse with them, and there probably aren't a lot of solid pathways to do that, and it would be very expensive for you to fight them. And that's why it's so important for us to come up with our own kind of guidelines for terms of service, right? That would be a counter to theirs, because theirs is so broad and so open to whatever they want to do. Typically, most people don't even read the terms of service, so they don't really know what's even in there. So it's easy to be taking advantage of right now. And I think that's the movement that we're starting to see right now. And one last thing I just want to mention on the exclusivity part is that we are seeing significant trends in the market right now for creators to only create content for one platform. So we're seeing significant movement in the early years of, let's say, podcasting. Content creation and distribution was typically a syndicated approach. Now, granted, that still is happening, but increasingly these big platforms have been siloing content creators to only create opportunities for creators that are publishing to their platform, creating a favorable environment, creating increased promotion for people that are dedicated to just creating content just to that one platform and not becoming cross-platform content creators. And so I think that's the other tension in the space right now that is growing in its, and cross linking between platforms is now disfavored by all of the platforms. So if you post a piece of content on YouTube, you can't really link to it in Facebook or link to it in X and get any traffic out of that anymore, because they want people that only publish to those platforms. And increasingly, that's where we're moving towards, which puts a lot of power in those big platforms to have an influence over content creator success or failure.
So I would agree with everything that Rob said, but all hope is not lost, because what I have found is it's usually not the platforms who are the platforms may squeeze you and may do certain things that are not as advantageous for the creators as we would like, but it is very rare that the reputable platforms are going to violate their own terms.
Right.
I think, right? To Rob's point, there are so many rights that you are generally conveying. I don't want to say it's almost impossible for them to violate it, but there's so much leeway in those terms. What happens much more frequently is a third party will infringe your copyright, your trademark, your name, image, and likeness. And we get these all the time on behalf of our clients, where our client, for good or bad, right? These are multi-billion-dollar companies that have marketing arms and agencies, and they still screw up sometimes. Yep. And they'll go and they'll use someone's picture without clearing the copyright to the photograph or clearing their persona rights. And they get either an email from the creator, or the creator will go to a plaintiff attorney who sends an immediate, demand letter saying, I want $10 million for the photo that you used in that ad campaign. And I will tell you, you don't need Clarence Darrow on the other side to get a brand's attention. So if a brand is using your content in violation of your rights, and they're probably not getting rights through the platform, right? If they're not clearing it directly through you or your representation, you probably have a cause of action, whether or not you're a celebrity or not. Right. And I will tell you that, having settled dozens of these types of cases, they happen all the time. You used my music, you used my face, you used my excerpt from my video, whatever it is. If there's a cause of action, there's an attorney out there that will take it. And if you don't have an attorney, again, you can go to a VLA if you have limited means. You can, we get demand letters all the time that are clearly drafted from ChatGPT or Claude or one of the models. And you still want to respond to it, because you have to take these complaints seriously. So I would say, Gary, to your question, there is something you can do for those third-party infringements. If it's a platform that's doing it, they got deep pockets, they've got a lot of lawyers. Chances are, it's not worth fighting that fight at this stage, unless you're lawyered up and you have means to fight it. But in other instances, I think there's definitely a path to protecting your persona.
Yeah, and I think one of the risks is that the content creator doesn't know that it's happening. And 100%. That's one of the core value propositions for the Royall.ai platform, is to create an infrastructure that can find those things and notify you that it is happening. And so you can take action, and hopefully that platform also creates terms of service around that creates a legal framework that makes it easier to file a complaint.
Yeah, 100%.
That's great. Rob, I want to take a question in a slightly different direction and talk about trust.
Okay.
And this is audience trust and advertiser trust. And it has to do with what has probably been the best format for getting a marketing message across through podcasting, which is host-read ads.
Mm-hmm.
Now, if instead of Rob reading the ad, Rob's clone is reading the ad, how does that impact the audience? How does that impact the advertiser? And is it something, and I'll ask you personally, is it something you would do?
I think we're in a kind of a gray area right now around all that right now. I do think that the advertising industry is pushing towards AI generated ads. I think mostly it's being done around audio right now. It's not being done around the video likeness quite yet. I do think that there are brands out there that are pushing the envelope on that and trying to do things, but some of them that I've seen, I know are stealing those likenesses of those big name podcasters like Joe Rogan or whatever, and creating those ads illegally. I think without the approval of Joe or any platform, because there really hasn't been any likeness licensing platform that's really been able to get in the middle of this until now. And so it is one of those things that we will push into an era of AI generated video ads. Now the question of trust gets into a whole nother sticky area, is that eventually AI generated content will be so ubiquitous and everywhere that it will be considered to be fairly normal. What will be unique is the human, the actual verified human reproductions or creation of ads. And that is where the increased premium valuation, I think, will come eventually. But I do think that there is a threat to a individual's personal brand to be represented in an AI likeness in the current market today. And I don't see that going away too soon. But it's something that I think is probably coming as people, see better reproductions, more authentic reproductions. It becomes harder to tell. And so, this whole movement that we're in right now of IDing things as AI generated, maybe just a temporary scenario that we're in. I think most people will just view any content as, well, it's probably AI generated, and unless it has a certified bug on there that it's actually certified human created content.
Certified human is kind of a scary idea. Put
well,
it on your
is,
forehead, right?
But that may be where we're going.
Yeah. So I saw something over the weekend that several of the professors at Harvard Business School are now creating classes being taught by their AI likenesses.
Yep.
And there's a professor named Busgang who's a well-known marketing professor. And he apparently, with the approval of Harvard Business School, sells a course for, I think it's $800, where you can interact with him, ask his advice, get questions answered, and get some lectures as well. I want to come back to the same question of trust. If you're an advertiser who might want to sponsor a class like that, if you're on the receiving end, how far do you think we are from the point where people will say, yeah, this is great. I can take advantage of this guy's thinking and I don't have to apply to HBS?
Yeah, I think in the long run, that's probably where we're going to wind up, is more and more people utilizing that as a way to extend their ability to service customers or clients 24/7, especially as you scale across many time zones and countries around the world. And then also that'll give the ability to translate into other languages too. So there are a lot of advantages to utilizing this technology to spread your ability to help others and build and grow your business of sorts, if it's that type of a business that relies on, customer interaction, customer assistance, and things like that. But I do think that the AIs need to get a lot better before that will be something that will scale across, human acceptance anytime too soon here. I think it could scale in the next couple of years where we'll see that become fairly normal.
Yeah, the clip that I saw essentially has a literal talking head, where you see the mouth move, but the body doesn't.
Well, that's
so,
not believable. So you have to worry about
I know.
Trying to
For
fool
$800,
anybody.
maybe it's a good deal.
Yeah.
I don't know. We're getting toward the end of the time here, but I want to make sure we enable you both to give some advice that might be homework for the audience. For podcasters here or influencers or whatever the background might be, could you give one or two things that they should do the rest of this week to help them better protect and to better monetize their identity as creators? And, I'd ask you both to answer this.
Well, given what I just went through with the Royall.ai platform of going through the multi-step and very complex layers of kind of creating a vault of my likeness, it feels like that is probably a pretty proactive step to take to be kind of a leader in that movement towards trying to build more and more creators that have gone through this process that then can be aggregated over a period of time to build some momentum around a collective effort, just like the music industry did with their music licensing. And I hate to say that to some degree, because I know that there's been a lot of problems with music licensing over the years. And one of the areas that has struggled is podcasting. We still don't today have rights to use copyrighted music in our podcasts because, and it's really not really a rational thing right now, but it's also an economic issue as well. But I think it being proactive about creating your own likeness vault of sorts and start setting yourself up for being a part of this movement that I think will continue to accelerate and grow as a way to take more control back of your content. And also at some point we'll probably be able to copyright and license the content libraries that we've all created, either in our podcasts or in videos that we'll be able to upload, and that could be used as a reference point to finding illegal use of our content.
That's great. Rob, for those of the audience who haven't seen the Royall Vault process, could you just give a brief description of what's involved there?
Yeah, you just go in and create an account, and it walks you through a step-by-step process of, you have to have a microphone that is good quality, and you read a bunch of scripts in various tones and inflections and in various contexts. It can take probably 20 minutes or more to go through most of the steps. If you're fast through the process, it could take maybe a little bit longer. But what you've done is you've created a deep catalog of content that platform can use to identify unauthorized use of your voice, but it can also be used as a selling tool to sell the opportunity of using your content and your voice and your likeness for the future of creating content online. And I think that process also applies to my physical likeness, my face, it's like a full body scan, multiple sides, face, side face, all that stuff it captures. And, if you're concerned about privacy, I could see where you might be a little bit freaked out about it. But but I think it's being captured for a very valid reason, and that is to create opportunity for you, but also to identify infringing uses of your likeness too. So there's two sides of this equation. So that's what I would advise, is just get in there and create an account and get your likeness into the platform as soon as possible.
That's very helpful, Rob. Thanks. Matt, your thoughts, and let's wrap it up with this. Any advice that you should give to someone listening as to what they should do this week?
Yes, I think that's great for monitoring purposes, to monitor people that are utilizing your likeness. One way to protect, there's nothing you need to do in order to protect your name, image, and likeness, but to the extent you have content or trademarks, I think, again, you ask a hammer, everything looks like a nail. So I'm coming from a legal angle here. I think on the monitoring side, places like Royall make complete sense for monitoring. On the protection side, if someone is infringing your content, right, it needs to be, your work needs to be registered before you can actually sue someone. So if you have a book or you've got a series of podcasts or videos, consider copywriting them and getting registrations. It's very easy to do. You can do it yourself without having to hire an attorney. If you're using a logo or a design or a catchphrase or something, consider trademarking it. These are ways that you can protect your IP in a legal capacity. And then I think it's surrounding yourself with a good, strong team, advisors, lawyers, agents, to the extent you're at a level where you can start bringing in representation. I think it's always important to bring in folks that advisors, folks that know the area, and don't go out and hire a real estate attorney, right? You want to hire someone who knows the area, unless you're looking to close a real estate deal, then obviously do that. But find people who know the industry, know the area, and can really advise you and understand your worth. So in terms of homework, I would say take a catalog of the IP that you have and consider whether it's worth investing some time and money to put some legal protections around it through either copyrights or trademarks.
Excellent.
Yeah.
Well, Matt, Rob, thank you so much. This has been an informative and somewhat entertaining conversation.
I'll dance next time.
Yeah, please do.
Yeah, I didn't tell enough jokes, I don't think, though.
Well, as soon as we get the music rights, we'll put a music bed under it for the next one.
That's right.
But thanks, everybody, for joining, and I hope this was helpful to you all. Have a great day, everyone.
Thanks, everyone.
All right.
Take care.
Thanks, everybody, for being here. Yeah.
Bye-bye.